optioned this book in 2019, and at the time it had sold just under 1 million copies. And I had never read
Why did you read it? Yeah.
Alright, if you're watching this on replay and don't feel like listening to a few minutes of intro, just skip ahead to when the document shows up on screen. That's where the actual breakdown starts. I haven't been covering much over the past month because things in the Justin Baldoni and Blake Lively situation slowed down, which was expected. We're still waiting on the judge's ruling on the summary judgment motion and judgment on the pleadings, so there hasn't been much movement. I decided to take a bit of a break while I could, since if this heads to trial it's going to get very busy, so I've mostly been focused on my regular day job instead of YouTube lately. I probably wouldn't have even seen this latest development if people hadn't sent it to me, because it came out of the New York State court case, not the federal one. This is tied to the anti-SLAPP action that the New York Times filed against the Wayfarer parties. They've now asked for a stay because they intend to appeal the federal judge's dismissal of their lawsuit against Blake Lively, Ryan Reynolds, Leslie Sloan, and the New York Times at the moment. The only active case is Lively versus Wayfarer, along with a separate but related Jones case involving publicist issues, and that one doesn't even have a trial date or summary judgment deadlines yet. The case they're appealing was dismissed last summer. I remember seeing the ruling at a very odd hour while I was in Australia preparing to fly home. The judge essentially gutted most of Justin Baldoni and the Wayfarer party's claims, dismissing Ryan Reynolds and several others entirely, leaving very little standing. Some minor claims were dismissed without prejudice, meaning they could have been amended, but the major claims were dismissed with prejudice, which means they can't be refiled, though they can be appealed. There was some confusion when TMZ reported that the Wayfarer parties had run out of time to appeal, but that wasn't accurate. The clock for the appeal doesn't start until the federal judge rules on Blake Lively's motion for attorney's fees, and that hasn't happened yet. So technically, no appeal is on file because the timing hasn't even begun. Meanwhile, the New York Times filed an anti-SLAPP action in New York State court seeking attorney's fees, arguing that Wayfarer's lawsuit against them was improper. Wayfarer is opposing that request and asking for a stay, saying they plan to appeal the federal dismissal of their claims against the Times. That's what we're looking at now. If you can't find it on Pacer or Court Listener, it's because it's in state court, not federal. The document explains that both the state and federal cases stem from the dispute between Blake Lively on one side and Wayfarer and Justin Baldoni on the other, related to the production of the film. In the original Southern District of New York action, Wayfarer and Baldoni accused the New York Times of defamation and false light over a December 2024 article and related video that allegedly described a smear campaign against Lively in retaliation for her accusations of misconduct. And I've said this before, the whole bot smear campaign narrative has become incredibly common. If people are upset about something you actually said or did, that's not necessarily a smear campaign, it might just be backlash. If someone is spreading completely false and defamatory information, that's different. But when there's video or documented evidence of someone's own statements, the real question isn't who exposed this, it's did you actually say or do that? If the answer is yes, then the conversation shifts. So that's where things stand. The New York Times is pushing for summary judgment in the state anti-SLAPP case to recover fees, and the Wayfarer parties are opposing and asking for a stay while they prepare to appeal the federal dismissal. Whether that's a standard procedural move or more of a delay tactic is hard to say, but they have formally declared their intent to appeal. The document continues by explaining that what alleged smear campaign was supposedly carried out in retaliation for Blake Lively's accusations of misconduct during filming. In June 2024, the federal court dismissed the claims against the New York Times on a motion to dismiss. Later, in October 2025, the federal court issued an order effectively extending Wayfarer's deadline to appeal that dismissal so the timing would align with a related, overlapping case that's still pending. Despite that, in September 2025, the New York Times filed a new action in New York State court under the state's anti-SLAPP law, seeking to recover attorney's fees and costs it incurred defending against Wayfarer's federal lawsuit. The Times acknowledges that its anti-SLAPP claim is entirely based on the federal court's dismissal of claims that Wayfarer says it intends to appeal to the U.S. Court of Appeals for the Second Circuit. Because of that, Wayfarer argues the anti-SLAPP action is premature and should be stayed to avoid duplicated efforts, wasted judicial resources, and potentially inconsistent rulings. The background section lays out the timeline. On December 20th, Lively filed a complaint with the California Civil Rights Department alleging sexual harassment during production and a retaliatory smear campaign tied to the film's August 2024 premiere. The filing claims that no later than October 2024, Lively had been collaborating with the New York Times on what Wayfarer characterizes as a one-sided and defamatory article about Justin Baldoni and others. The Times published its article on December 21, 2024, one day after the CRD complaint was filed, along with a related video explaining its reporting. On December 31, 2024, Lively filed a federal lawsuit against Wayfarer, Baldoni and others, asserting claims including sexual harassment and retaliation. Then on January 16, 2025, the Wayfarer parties filed their own federal lawsuit against Lively, Ryan Reynolds, Leslie Sloan, and Vision PR. By January 30th, the federal court consolidated the two cases for convenience and judicial economy, finding that they involved common questions of law and fact. When the New York Times moved to dismiss Wayfarer's defamation and false light claims, the court granted the motion and dismissed those claims without leave to amend. The Times later moved for entry of final judgment, which Wayfarer did not oppose. In October 2025, the federal court issued an order asking why final judgment should not be entered, and why certain motions should not be dismissed as moot. Given that the dismissal had already been granted and deadlines to amend had passed, neither side objected. Shortly after, Lively asked the court to hold Wayfarer's deadline to appeal until after her motion for attorney's fees was resolved. In a memorandum and order dated October 31, 2025, the federal court explained that under the Federal Rules of Civil Procedure and the Federal Rules of Appellate Procedure, certain motions for attorney's fees can effectively pause the appeal clock, specifically, if a qualifying post-judgment motion is filed before a notice of appeal. The time to appeal doesn't begin until the court rules on that motion. The court noted that district courts are permitted but not required to delay finality for appellate purposes until fee disputes are resolved. Here, the judge determined that doing so would promote judicial efficiency, since any appeal related to fees would substantially overlap with an appeal of the underlying dismissal. So, as it stands, the appeal clock on the federal dismissal hasn't started yet because the fee motion remains unresolved. Meanwhile, the New York Times is pursuing fees in state court under anti-SLAPP law, and Wayfarer is asking that case be stayed while they prepare to appeal the federal dismissal. This next section is really the heart of Wayfarer's argument for a stay. They point out that the federal court already considered whether delaying the appeal timeline would unfairly prejudice the New York Times and concluded it would not. The judge specifically said that any prejudice to the Times from delaying the appeal was minimal, while the benefit to judicial efficiency by avoiding piecemeal appeals was substantial. Based on that, the court entered final judgment under FRCP 58E, treated Lively's pending fee motions as Rule 59 motions for appellate timing purposes, and denied the Times' motion for partial judgment as moot. Judgment was formally entered on October 31, 2025. Wayfarer now makes clear that it intends to appeal both the dismissal order and the judgment. The planned grounds for appeal include arguments that the federal court erred in concluding they failed to plausibly allege actual malice and that the court improperly relied on what Wayfarer characterizes as cherry-picked evidence rather than accepting their well-pleaded allegations as true at the motion to dismiss stage. Crucially, Wayfarer emphasizes that its time to appeal has not expired because Lively's fee motions are still pending. Meanwhile, Wayfarer's own dispositive motions judgment on the pleadings and summary judgment against Lively are still awaiting rulings, and trial is currently scheduled for May 18th in the state anti-SLAPP case. The New York Times is seeking attorney's fees and costs under New York's anti-SLAPP statute, arguing that the federal dismissal proves Wayfarer's lawsuit lacked a substantial basis in fact or law. Wayfarer disputes that and filed an answer with affirmative defenses. In January 2026, the Times moved for summary judgment, asserting that the federal court's dismissal alone establishes that Wayfarer's claims were baseless. Wayfarer's stay argument focuses on the risk of inconsistent rulings if the state court grants summary judgment to the Times based on the federal dismissal, but the Second Circuit later reverses that dismissal and reinstates Wayfarer's claims. The foundation of the anti-SLAPP judgment would collapse. In that scenario, one court would have determined the lawsuit lacked a substantial basis, while the appellate court would have effectively ruled the opposite by reinstating the claims. They also argue that without a stay, everyone wastes time and resources. The state court would have to fully adjudicate the summary judgment motion, possibly including argument, conferences, and further proceedings while the federal appeal is pending. If the dismissal is overturned, all that work could become irrelevant. On top of that, Wayfarer could be forced to satisfy a fee judgment and potentially appeal that judgment at the same time it's appealing the underlying dismissal to the Second Circuit. Another point they raise is sequencing. The federal SDNY action was filed 9 months before the state anti-SLAPP case, and courts generally give deference to the first filed action when there are overlapping issues. Finally, they argue that the Times can't claim unfair delay here because it did not object when the federal court extended the appeal timeline in connection with the pending fee motions. By contrast, Wayfarer says it would face real prejudice if forced to litigate and potentially pay a judgment in the anti-SLAPP case while simultaneously pursuing an appeal that could nullify the basis for that judgment. So in short, Wayfarer is asking the state court to pause the anti-SLAPP case until the federal appeal is resolved, arguing that doing so promotes efficiency, avoids inconsistent rulings, and prevents unnecessary expense on both sides. Okay, so to clarify the appeal question first, if they appeal the dismissal, that would cover the entire dismissal order, meaning it applies to all the dismissed defendants in that portion of the case. including Ryan Reynolds, Leslie Sloan, Vision PR, and the New York Times. It's not piecemeal. If they go up on appeal, it's the whole dismissal they're challenging. Now, this affirmation from Kevin Fritz largely restates what we already saw in the prior motion, but it fills in the procedural background more formally. He walks through how this all started. Blake Lively filed her complaint with the California Civil Rights Department, and the next morning the New York Times published its article by Megan Twohy. Wayfarer characterizes that article as the result of months of coordination, saying Lively had been working with the Times no later than October 2024. They also point out that notice to respond was allegedly given within about 24 hours, shortly before publication and around the holidays. The federal litigation timeline follows what we've already covered. Lively filed suit in federal court asserting sexual harassment, retaliation, breach of contract, and emotional distress claims, some of which she later dropped. The Wayfarer parties then filed their own federal lawsuit asserting claims including civil extortion, defamation, false light, and interference-based claims. The court consolidated the cases for efficiency. The Times moved to dismiss. On June 9th, the federal court dismissed Wayfarer's claims against the Times without leave to amend. That's Keno amendment allowed. The only path left is appeal. After that, the Times moved for entry of final judgment, and Wayfarer didn't oppose it. Then the court issued an order to show cause about final judgment and mootness of certain motions. Neither Wayfarer nor the Times objected. Lively, however, responded by asking the court to enter final judgment, but treat her pending attorneys' fee motions as Rule 59 motions for purposes of appellate timing. That's the procedural hinge here. Under the federal rules, if a qualifying post-judgment motion like certain fee motions is pending, the clock to file a notice of appeal does not start until that motion is resolved. The federal court agreed that this approach would promote judicial efficiency and avoid piecemeal appeals. It specifically held that any prejudice to the New York Times from delaying the appeal was minimal compared to the benefit of handling all related appeals at once. So final judgment was entered on October 31st, but the appeal clock hasn't started because the fee motions are still pending. Wayfarer now formally states it intends to appeal both the dismissal order and the judgment. The main arguments they preview are: the court allegedly erred in finding they failed to plausibly allege actual malice regarding the Times smear campaign statements. On a Rule 12b6 motion to dismiss, the court allegedly relied on cherry-picked materials instead of accepting Wayfarer's well-pleaded allegations as true, which is the standard at that stage. That's the crux of what they plan to argue to the Second Circuit. And tying this back to the state anti-SLAPP case, everything the Times is seeking their fees and costs is predicated on the federal dismissal. If that dismissal is reversed on appeal, the entire premise of the anti-SLAPP claim could unravel. That's why Wayfarer is pushing for a stay. They're essentially saying, don't make us litigate and potentially pay a fee judgment based on a dismissal that might not survive appellate review. Procedurally, their position is coherent. The federal court itself emphasized efficiency in avoiding fragmented appeals. Wayfarer is now using that same logic to argue the state court should pause the anti-SLAPP case until the federal appeal is resolved. Alright, so to wrap this up in plain English, the appeal clock on the federal dismissal has not started yet because Blake Lively's motions for attorneys' fees are still pending. Under the federal rules, once those fee motions are resolved, then the time to appeal begins. Until that happens, Wayfarer's window to appeal remains open. Meanwhile, their motions for judgment on the pleadings and summary judgment in the main federal case are still pending as well. If those aren't granted, trial is currently set for May 18th. Separately, in state court, the New York Times has filed its anti-SLAPP action seeking attorneys' fees and costs. Their argument is straightforward. The federal court dismissed Wayfarer's claims against them, therefore the lawsuit must have lacked a substantial basis in fact or law, which under New York's anti-SLAPP statute entitles them to recover fees. The Times moved for summary judgment on that claim in January, arguing that the dismissal alone proves their entitlement. Wayfarer's response is essentially, hold on, we intend to appeal that dismissal. If the Second Circuit reverses it, your entire anti-SLAPP theory collapses, so this state case should be stayed until the federal appeal is resolved. That's where things stand procedurally. Nothing has been appealed yet, no ruling on fees yet, no ruling yet on the pending dispositive motions in the main federal case, and the state court now has to decide whether to grant a stay in the anti-SLAPP action. So for now, it's mostly procedural positioning while everyone waits on the next federal rulings. Whenever the fee decision drops or if the stay is granted or denied, that'll be the next real development worth digging into.